Now, all that I said before, the lack of a statute of limitations on an unfiled tax return and the penalties applied to unfiled FBARs, after several years of advocacy by us and others with the IRS, beginning in March 2009, we finally persuaded the IRS to adopt a program far more open to innocent non-filing. So what we've said to the service since March of 2009 is that there are hundreds of thousands, if not millions, of U.S. citizens living around the world who have no idea of this obligation to file this foreign bank account report. They live in a foreign country. They have their bank accounts in a foreign country. Isn't that a big surprise? And effectively, they pay tax in a foreign country. Most of them don't know they have to file U.S. tax returns, and they sure don't know anything about these foreign bank account reports because they don't consider their bank accounts foreign. And finally, in June last year, June the 18th, 2014, the service adopted the Streamlined Foreign Offshore Procedures, SFOP for short. And I have to say, it's a reasonably good program. I have some problems with it still, and I've hassled the service about them, but generally, it's a very good program because it really is an amnesty, which I'll talk about in a minute. It requires that you be a resident outside the United States for at least 1 year during the last 3 filing seasons. So if you were to file in 2015, you would have had to have been out of the United States for at least 1 year during the tax years 2011, 12, and 13. It eliminates all tax penalties and all FBAR penalties. It requires only the payment of tax due plus interest on that tax. It effectively offers an amnesty to Americans living overseas who can demonstrate non-willfulness. It requires the filing of 3 years of late returns, that is, returns that should have been filed already. And if you're doing the math, 2011 should have been filed in 2012, 2012 in 2013, 2013 in 2014, and we're now in 2015, and you've yet to file. You've got 3 years of late returns to file. It also requires 3 years of amended returns if foreign source income was not reported on a return that has already been filed. So if you filed a U.S. tax return and you haven't included your Greek source income or your French source income or your Italian source income, you only reported your U.S. source income, then you would file 3 years of amended returns to report your foreign source income. It requires the filing of 6 years of late FBARs, FBARs that should have already been filed. I really don't know why they kept that 6-year limit in, and I can't get a good answer, but they've kept the 6-year limit in. So if you're doing the math again, 2008, 9, 10, 11, 12, and 13 are all late. They should have been filed already. So to file an SFOP, you're going to file 6 years of FBARs. It also requires the filing of a certificate of non-willfulness. The IRS has developed a form for this called the Form 14653, and a statement of facts explaining your non-willfulness. Now, the IRS has refused to provide any guidance on what it means by non-willfulness. Now, why? Well, because they don't want to write your script for you. Right? They're not going to sit there and say, oh, here's all you have to do. Say this, and we know it's not willful. Right? We consider this the most important piece of paper in an SFOP filing, because this is your personal statement given under penalties of perjury that explains your non-filing and why the IRS should read your statement of facts as supporting your non-willful intent. Simply, I didn't know I had to. Signed, George. Not likely to give much explanation. And all SFOPs are filed with one filing center in Austin, Texas, where the certification and the statement are read, and if the statement is accepted, the return is then forwarded to another service center for processing. So I urge you not to take this statement of facts lightly. Now, there is no stated deadline for filing an SFOP submission. Currently, the program is unrestricted. So it's not like your tax return. Remember, your tax return has to be filed on the 15th of June, 2015. Your 2014 FBAR has to be filed on June 30th, on or before June 30th, 2015. Your SFOP filing has no deadline. The IRS has not said it has to be filed by April 15th, July 20th, October 28th. It has said nothing. It says it's open-ended. Now, remember, the SFOP are a modification of normal IRS procedures for innocent, non-compliant overseas Americans, and a great improvement over the previous June 2012 Streamlined compliance program. Anybody who attended this session last year will have had me say some pretty harsh words about the SCP because I thought it was far too restrictive. It was still a very criminally minded program, and it really restricted the application to a large number of people who had some tax exposure. And lastly, you had to fess up all the facts without any guarantee that you'd be accepted in the program. So we considered it to be basically a useless program and told the service as much. Now, the SFOP, which I consider to be a reasonable program and very, very good compared to the alternatives, will not be available indefinitely. The problem is nobody can predict when it will stop. When will the IRS terminate the program? Can't say. They've offered no assurances so far, and we've requested them, that there will be any advance notice of termination. So we have advocated that the service adopt a commitment that it will not terminate the SFOP without at least 6 months' notice. Now, I haven't received a response to that request. I don't know whether it will or won't. But all you need to understand sitting there is that the SFOP is a significant modification of the current law and regulations related to late filed returns and late filed FBARs. So it's a great opportunity if you're not in compliance now to get into compliance with literally no penalties on the FBAR side.